All right, so tonight we're going to start with Unit 19, which is going to deal with leases. Okay, we're going to start off with discussing the requirements of laws related to the leasing of residential real estate. We're also going to identify the characteristics of the 4 types of leasehold estates and the various types of leases. And we're also going to describe the requirements and general provisions of a valid lease. We're also going to explain the key points of the Texas Landlord and Tenant Act, because they're all broken down there. And so we're going to go ahead and get started in regards to a lease. Okay? So one of the key things that I want to tell you, just because the fact is most people that I'm talking to tonight, most of you at least once in your life have ended up, you've been in a lease. Okay? A lease, as it says, is a contract between an owner and the tenant. Okay, and so, Mr. Eugene, you could own some property, and thus, if you're the owner, you're called the lessor. Okay, and if you're a tenant, say, Miss Linda, you're renting from Mr. Eugene, you're called the lessee. Okay, so in this situation, it's a contract between both parties. Now, there is going to be a transfer of right, though. Remember those bundle of sticks we talked about? There is a transfer of right to the exclusive possession and use. Okay, and you give them a specific period. Now, one question that's always asked to me every single semester I teach is, Mr. Eugene, if Miss Linda's renting from you, okay, and Miss Leela comes in and she says, I want to purchase your property. Can you sell your property with Miss Linda currently living in the property?
No.
But Miss Linda's living there.
Okay.
So you're telling me that you can still sell your property without Linda? Well, you got to have Linda's consent.
No.
No?
It's my house.
It's your house, but she lives there.
So,
That's right. So in that situation is, yes, you as an owner can sell that property to Miss Leela without Miss Linda's consent. A lot of people think that, well, I can't sell my house because it's leased, and and if I sold it, Miss Linda's going to be mad, and I'm just not going to do it. Doesn't matter. Who owns the property? Mr. Eugene. So if Mr. Eugene owns the property, he's the one that gets to make the decision of who owns it. Now, what if Miss Leela buys the property? That means, Miss Linda, that Leela can kick you out, right? Is that correct? No? What does that mean?
You have a lease.
That means that you get to stay there until the lease terminates.
right.
So Miss Leela cannot buy the property and kick Miss Linda out. Okay? Miss Linda has to stay till the term of the lease. Now, this was one thing that was brought up at a training the other day that I was in. Say, though, that Miss Leela is buying, or let's play this out. Mr. Eugene, Miss Leela wants to buy your house, and she goes over and she says, I'm going to buy your house and all this. And when does Miss Linda's lease expire? And you say, well, it expires April 1st. Okay? And so that's, say, 2 days after closing. Miss Linda's supposed to be out. Right? So Miss Leela goes ahead, buys the house from you. April 1st comes around. Miss Leela's ready to move in. And guess what? Miss Linda's still in the property.
Yep.
Miss Leela says, get out of my property. She says, no, I'm not. There's an eviction moratorium. And that means the government says that you can't kick me out. So I'm staying here. I ain't moving out. Miss Leela says, no, I bought the house. Your lease expired. Get out of my house. She says, I'm not. Sue me. Well, what happens? When there's an eviction moratorium in place, what does that mean?
She can't do nothing.
She can't push her out at all
Stay there.
because there's no court that will enforce her to be kicked out. So in that situation, what happens? Miss Linda gets to stay there. Miss Leela is now homeless.
That's right.
We ran into that issue. Okay? So in these situations, what happens is thankfully things are kind of getting back to normal. But during that time, when there were moratoriums in place, tenants could tell the landlord, I ain't moving. What are you going to do about it? Okay? And there's nothing you can do. So again, there are those situations, and you got to be prepared for those. Again, it is the conveyance of a leasehold estate, not a freehold, it's a leasehold, and the landlord retains the right for the payment, or retains rights for payment for use and the reversionary right for possession after the lease's term. Now, we talked about some of these already in regards to related laws that deal with leasing. The number one, of course, is the statute of frauds. And the statute of frauds is basically that it must be in writing if the lease is for what? More than 1 year. If it is less than 1 year, what happens? Watch this. This is a little trick. They'll catch you on the test, okay? Mr. Eugene, you want to go and lease Mr. Jacobs' property. Mr. Jacobs says, okay, Mr. Eugene, you're going to pay me $1,500 a month, and you're going to pay me $1,500 to stay in the property, and you're going to stay for 1 year. Does that need to be in writing? No. 1 year and a day. If it's more than 1 year, it has to be, and more means more than a year, so by a day, it has to be in writing. He can do a verbal contract with you for 1 year with a handshake. Okay? However, would you advise that? Never. Never. Okay? Another one is that the agency disclosure. Again, Miss Linda, I'm going to let you talk about this real quick. What's this IABS form? What's all about? That's nothing important, right, Miss Linda? You don't need to give the IABS form to anybody, right?
Yes,
Why do you need to give that form?
because of the fact that it's basically a protection for you.
Well, it discloses, it tells the clients what, Miss Linda?
My mind's shut.
Who represents who?
Yeah.
It ends up in this situation, say that I'm going to Mr. Colton, and I tell Mr. Colton, I say, I'm going to represent you. And Mr. Colton goes over here, and, I'm representing him. I need to give him the IABS so he knows who my broker is. He knows who the company I work for and how to get a hold of these people. What about if he's not happy? Can he call Trek? He needs all that information. So the IABS gives him that agency disclosure. Okay. What about sex offender disclosure? Do you have a duty to tell people about sex offenders? No, you don't, but is it recommended? Yeah. Now, be careful though, like we said before, talk to your broker, always talk to your broker and see what your broker says. Because of course, the broker makes what? The final decision. Okay? So the broker in this particular situation needs to make that decision of, do you share that? Okay? But what happens, Miss Linda, if Stephen went online and he's in a rush and he's getting his phone and he's searching real quick and he's looking and he's typing to see, is there anybody around here that is a sex offender? And he's searching, he finds a Eugene Nobles. Oh, it's Eugene Nobles is a sex offender.
Oh, yeah.
Okay? And so he points back there and says, that guy back there, he's a sex offender. It says right here on this deal. Well, what's the problem, Mr. Eugene or Mr. Stephen, if you just did that?
You slandered his name.
Are you 100% that's Mr. Eugene that's on here?
No.
So could that be the wrong person?
Could be.
And could you be, like you said, slandering his name? Yeah. And then Mr. Eugene, if Stephen's around telling everybody you're a sex offender, what are you going to do to Mr. Stephen?
I'm gonna sue you.
You're going to sue him for slander.
That's right.
So that's why when you go through these things, you be very careful telling somebody who's a sex offender. Because some of these databases, Miss Linda, you worked in databasing before, can people make errors when they're filling out stuff?
Yes.
And sometimes that information can be put wrong. They may say the unit 1 is supposed to be 104 and they put 140. And then Garrett's in 140. Well, it's supposed to actually be Mr. Stephen, but instead y'all are saying it's Garrett. So now everybody's saying that Garrett's a sex offender. You see a problem there? Okay, be careful when you're dealing with this. What about lead-based paint, Steph? What's so important about lead-based paint?
It's dangerous.
It's dangerous. Can you eat it, Mr. Eugene?
Sure, I do all the time.
You do it all the time. Tastes good, right? Okay. What happens when you eat a lot of it, Mr. Grossman?
Lead poisoning and death.
You die. Mm-hmm.
What? I thought it made you strong.
No, you die.
Oh,
Okay.
that's asbestos.
Yeah. So in that situation, if the house is built prior to what day? What was it, Mr. Eugene?
1978.
1978. If it's built prior to 1978, you have to give a lead-based paint disclosure. There's also the Americans with Disability Act. We talked about this before. The Americans Disability Act, it means what? You have to accommodate some people if you're a landlord, okay? And also fair housing. Remember those words we put up one day where we're talking about you can't use white, you can't use black, you got to watch those things, okay? Fair housing. It's equal access to fair or to housing without differentiation in terms or conditions because of race, religion, sex, familiar status, color, national origin, or handicap. You cannot in these situations discriminate based upon any of these items that are listed. Okay? There's a special focus on accessibility. Remember, it's to allow full enjoyment, keyword there, full enjoyment of housing and related facilities for persons with handicap. So that means there has to be reasonable modifications, such as a permit, a structural change to be made on the premises, or accommodations, make a change, exception, or adjustment to a rule, policy, practice, or service. Now I can tell you, and Ms. Leela probably will tell you, some people truly need this. They truly may need some of these. But then unfortunately you have people out there that don't need it or are taking advantage of it. Okay? And I can tell you one of the key ones that's always an issue in real estate is pets. And it's sad to say, and Ms. Leela probably knows exactly what I'm saying, there are some people that truthfully and honestly, they need a pet to be with them, and it helps calm them. Okay? They have severe anxiety or maybe other mental or even physical issues, and they need a pet to calm them down. Okay? But you have some people that like to skirt the system. So Garrett and his girlfriend want to go get a new puppy. Okay? And Mr. Eugene, you have a no pets policy in your property. So Garrett comes and says, Mr. Eugene, I would like to have a pet. And you say, heck no, not going to do it. No dogs in my deal. So he goes online to Google and he fills out a form. He still goes, gets that puppy, and he sends it to you and says it's a service pet. He paid, some people don't even pay nothing, some of them print them offline. But he goes and he gives you that form, Mr. Eugene, that says he has a service animal and that he's asking for an accommodation. Guess what? You may have to actually make that accommodation. And then that supposed quote unquote service pet, guess what happens? Isn't a service pet. Okay? That dog goes in and guess what happens? Destroys the house. Demolishes it. Then when they leave, you try to go collect from him, and he says, well, it's a service animal. You can't collect from him because it's a service animal. Okay? So in some of these situations, you have to be very, very careful. And that's one of the things in real estate that can be very problematic is when you don't want to end up making these accommodations. You could have a fair housing violation filed against you. Okay? Now, what about these leasehold estates? Well, there are different types of leaseholds. You're going to have to know these guys and gals. No matter what, you're going to have to actually know the different types. But the first one is an estates for years. It's a lease for a definite period of time. There is a specific start and stop date. So it actually says January 1st to December 31st, this is your term. Okay? There is no automatic renewals. Zippo, none. And there is no notice required to terminate because it automatically terminates on the date that it says on the stop date. There is a periodic lease, which is an estate from period to period. And this is a lease for an indefinite period of time. It automatically renews with payment and acceptance of the rent. So if I go over and I stay at your property, Mr. Eugene, and I pay you and you accept it, well, I can stay there as long as I want. As long as I'm paying and you're taking, we're good. Okay? But there is a notice that has to be required if you want to terminate. Okay? There is a tenancy at will. And this, of course, is a lease for an indefinite term as well. Okay? But it is at the will of each party. So I can stay here as long as I want, and you can let me stay as long as I want, but at any time you don't want me here anymore, guess what? You provide me a notice, and it terminates at that point once I have that notice. Okay? Normally you have to give 30 days. Now, the termination is on the death of either party. So if either of y'all die, then it automatically terminates. And the tenant enters rightfully and holds over rightfully. Okay? Now this one's, Mr. Eugene, this is your favorite. This is the favorite of all for you, Mr. Eugene here. It's called an estate at suffrage. What's the word suffrage sound like to you, Mr. Eugene?
Money, pain.
Pain, right? So in this situation, it's a previously lawful tenant, Mr. Grossman. He's at a lease with you, and he was lawful. He was paying you, so he stayed there like he's supposed to. But when his lease expired, he continued to stay without your consent. So his deal ended on the 31st of last month, and he's still there. Okay, so the tenant suffered or permitted to remain. And in this situation, Mr. Eugene, it may require an eviction. Okay, the tenant enters rightfully, but then holds over illegally. Right? So, and this happens a lot. Sad to say, but this happens a lot. Especially when there is an eviction moratorium. And they know there's no way Mr. Eugene's getting Mr. Stephan out. Okay? So these kind of break down your leasehold estates. You have these different ones that are shown right here on this little chart here for you. So now we want to jump into the validity of a lease. And if you'll notice from contracts course, and when we talked about contracts in this class, this looks very similar, doesn't it, Miss Linda? They're mainly the same: an offer and acceptance, consideration, capacity to contract, legal objectives, and legal description. Pretty much all the same things as any other contract. Okay? And the covenant of quiet possession, which is pretty much it's an implied part of that contract. Okay? Now, the common lease provisions, of course, are going to deal with the term of the lease, and you have to actually have start and end dates. You can't go, Mr. Eugene, and say, Stephan's going to move in January 1st and leave it for indefinite. Because how are you going to kick Stephan out after 5 years if you don't put a termination date? Have you what's the word? Have you breached anything if there's no end date?
Technically, no.
Technically, no. So in that situation, is you must have a start and end date. The possession of the leased premises also must be provided. And Mr. Eugene, you also have to tell Mr. Grossman what are the uses. What can he do with that premises? Okay. In regards to improvements, neither party is required to make improvements, or the tenant improvements are with landlord consent and remain on the lease termination. So either you can tell Mr. Grossman, you can't improve my property at all, or you can, but you have to have my consent. I'll tell you, don't ever let a person, like a college student, that's what I'm coming to, I'm going to rephrase that. Don't let a college student, quote unquote, improve your property. Why do I say that, Stephan? What kind of improvement work you going to get?
Big mess.
A big mess. Why do you say that?
Unless he's construction, he probably don't know what he's doing.
Yeah, he probably don't know jack crap, right? So in that particular situation is, Mr. Eugene, Stephan comes to you and says, I want to paint one of the rooms. Is that okay?
He'll be super gluing crown molding to it.
Exactly. Stephan's going to come in and repaint your entire house for you, Mr. Eugene.
I don't think so.
Why?
No.
Why can't he? He wants to paint it.
Professionals, I don't do.
But he's going to save you money.
Don't care.
That's right. Because what happens is I've seen this before, when a person says they're going to paint, they're going to find the cheapest paint possible, and it's going to be everywhere, and especially if they have children, who's going to paint their house really? Because what happens, Miss Linda, when you have children and mama's painting the house? What do the children want to do?
Paint.
Mama, can I come help? And then what does mama do? Well, here, little kid, Johnny, paint right here, and then what happens? Everywhere. Okay?
All over them.
Exactly. That's why it's not a good idea for a tenant, unless that tenant actually is an expert in that, don't let them do it. Okay? Options and right of first refusal. You want to, of course, renew the lease or purchase property. Sometimes, Mr. Eugene, you may say, Mr. Grossman, if I decide to sell the property, I'll give you the first right to renew or buy it. Okay? Now, this is very key up here. The Landlord-Tenant Act basically does set occupancy limits, because way back in the day, people would shove into a room probably about this size. They would end up in some situations, they would probably fit maybe 50 people in here. Okay, they'd be laying on the floor, and sleeping bags and all that kind of stuff. Okay, or they put stuff in the wall and let people sleep on the walls and all. Well, under HUD, it's a 2-bedroom plus an infant with their parents. Okay. If it's in Texas, there's 3 adults per bedroom. So for each bedroom, you can have 3 adults, but no more. Okay. Mr. Grossman, could you imagine that in your house, at your bedroom, there could be 3 adults in your bedroom? How nice would that be,
I
sir?
don't really got enough room for my bed in there now.
Yeah, could you imagine 3 of you in there? Probably be a little problematic, right? Again, the owner needs a written occupancy policy, though. And most of the time, if you're using a realtor, it's already stated within the forms. But again, if you are doing it on your own, you need a written occupancy policy. You also need to have a rental application. Very key in this situation that the applicant must give the printed or online use of the tenant selection process. If you're going to use or do this on your own, say that Ms. Leela wants to rent property on her own, she don't want to pay nobody, she has to follow these steps. She has to keep it consistent. She can't say, well, for you, Stephen, you only need a 580 credit score. But for you, Mr. Eugene, you're a pain in the butt, so you need 750. Okay? You can't do that. You have to have the terms across the board set across the board. Okay? And it has to be given prior to them running their application. So you can't do this. Ms. Leela couldn't say, here, Stephen, fill out this application. Here, Mr. Eugene, fill out this application. Then Leela runs both of y'all's and then sees, oh, okay, well, I don't want Eugene in there, so I'm going to, he's got a 640, so I'm going to say he needs a 650. And Stephen, he's got good, so I'm going to give Stephen 5. You can't do that. It has to be all done prior to it all being taken care of. It has to be done before you run the applications. Okay. Before completing the application, of course, like it says, including the grounds for which the application may be denied. Okay, things such as criminal history or credit history. Okay, these are going to be very key, and you need to think these out. A lot of times people don't think about criminal until what happens? Somebody actually applies. And then in that situation, they want to turn the person down, but they have everything perfect on everything else except they have criminal history. What's the problem with that? Well, if they got a criminal history, what's that mean, Miss Linda? Well, if you didn't have that policy, then you got to probably accept them, even though you don't want them to. Okay. The applicant must sign an acknowledgement of the notice or acknowledge that receipt online. The application deposit is going to be similar to the earnest money. Again, an application deposit is going to be given with the rental application before the lease is signed. Very similar to your first month's rent most of the time. Most people, they'll end up, what happens, and I can tell you kind of how I do mine. I send over the application, the notice, get all that sent to them. And then once they complete it, we go through. Now, this is something else that I can tell you, and a lot of landlords don't like this, but the key thing is when an application is completed with a realtor, the brokerage, so let me just play this out. Say that, Mr. Eugene, you want me to manage or Stephen, you want Stephen to manage your property. Now, he's an agent, I'm the broker. You want Stephen to manage the property. I've let Stephen, I've given him the tools to do that. So Stephen manages your property. I go through, Stephen gives Miss Linda an application. Okay, so Miss Linda, you get an application. She wants to rent your property, Mr. Eugene. Stephen, you've given her the application. She's completed it. You've ran her background check, and you find out that Miss Linda has bad credit. And you got her entire credit history in front of you. Okay? Mr. Eugene, you tell Mr. Eugene, well, Mr. Eugene, I just ran Miss Linda's stuff, and looking from her information, I would not recommend that you accept this person. What's the very first thing you're going to ask Stephen? He says, well, I looked at their stuff and I don't think you should accept it. What are you going to ask for?
I want to see it.
I want to see it. I want to see her credit stuff. I want to see all her credit information. Send it over to me. And Stephen's going to tell you what? What do you tell him, Stephen? No, I can't send it to you.
Oh, that's right.
I can't send it to you because of what? Who did Miss Linda sign to have access to her credit? Did she put Mr. Eugene or did she put Noble's Realty?
Noble's Realty.
She put Noble's Realty. So in that situation, did she give us permission to share it with Mr. Eugene? No. So the only person that has access, so if Stephen sent it to you, Mr. Eugene, and Miss Linda finds out about it, lawsuit. Okay, so a lot of landlords, 99% of the time, they end up what? What do they do? The landlords in this situation, you have to tell your landlord up front before you even do anything. Now understand, Mr. Eugene, when I run this, I cannot share it with you because she has released the information to me. Now, if you would like her to change her application to put you, and you pay for everything, we're more than happy to do that. But understand that it's going to cost you a lot more money than if we were to run it. Okay? So you can do it, and you charge her, but I can already tell you, we do it for $50 per person. You end up, for you to get the same program, it's probably going to cost you $250, and you're probably going to pay it because Miss Linda's not going to pay more than $50 because that's the standard normal rate. Okay, so again, you got to be very careful when you're dealing with these applications. Again, it's the application deposit is going to be similar to the earnest money. It's given with rental application before the lease is signed. It binds the applicant with application, is reviewed, credit checked, etc. And if it is rejected, the application is rejected, then they refund that money back to them. But they never refund the credit check application, ever. So if Miss Linda, you paid that $50 to me and I read your credit and I see that it was a failure, you got a 400 credit score and it doesn't meet our stuff, Miss Linda, I'm sorry, you're declined. You'll get your application deposit back, but you're not going to end up getting back the fee, the application fee. And a lot of people get very mad about that. They also apply to other fees due when the lease is signed if the application is accepted. Now, the application fee, of course, is going to be the charge to offset the actual cost of the screening for the credit and criminal background. It does not have to be returned if the applicant rejected, okay, unless the landlord does not have a copy of a tenant selection criteria that's signed by the applicant, okay? So in that particular situation we want to make certain that as you're going through these, that you want to make certain that you make sure that you have that tenant selection, okay, that criteria, all right? You've got to make certain that you have that, because if you don't, guess what? You got to pay back that application fee. The security deposits. Now, security deposit, oftentimes this is what happens. So let me go back here real quick. You see that application deposit? That application deposit, if the application is approved, will oftentimes transfer to the security deposit. Okay? So if Mr. Grossman runs the application and approves it, Mr. Eugene, for you, and Miss Linda paid him $2,000, and understand this application fee here, this deposit, that's normally 1 month's rent. And so if Miss Linda paid her 1 month's rent, he approved it, well, then he's just going to transfer it to the security deposit. Okay? And so it safeguards against the tenant's destruction of the premises. It also induces the tenant to honor their agreement, and it encourages thorough cleaning on move-out. And it frequently is going to be 1 month's rent. So when Miss Linda wants to move into the property, Miss Linda would have paid her application. She'd have paid her application fee and deposit. So both of those would have ended up, here, can you get that too?
On that too?
So in that situation, what ends up happening is that you have the security deposit, which ends up in that particular situation. They turn around, they have the safeguard. You basically are making certain that you have that whole overall view. Okay, so it's 1 month's rent, but oftentimes when you go in, Miss Linda would have paid her application deposit, her application fee, and if it's approved, also her first month's rent. A lot of people think that once they pay this deposit and they pay their fee, that's it. I get to move in the property. No, it's not, because you still have to pay your first month's rent. So a lot of times it's very expensive. Now, security deposits must be returned within 30 days of the residential tenant's surrender of the property, or 60 days of the commercial tenant's surrender of the property. The return of the money or an accounting of the money that was withheld must also be given, and there's no obligation to return earnest money without the tenant's written notice of a forwarding address. Now, it's transferred to a new buyer, but not prorated upon the sale of the property. Now, in regards to late fees, it must be specified in the lease, and it must be a reasonable estimate of damages to the landlord for getting rent late. And there may be a charge after the rent has been unpaid 1 full day after the initial due date, and rent due on the 1st with late fees beginning on the 3rd. Now, there can be an assignment or subleasing. Now, they may not assign or sublease, however, without landlord's consent, which means in this particular situation that Stefan could not, in this particular area, he could not just turn around and just say, you know what, I'm just going to rent my property out to somebody else. He can't do that, okay? So in that particular situation, you can't just go over here and go through and end up basically just making stuff up. He can't just say that, you know, Stefan goes over and Stefan says, you know what, Mr. Eugene, I'll let you just start moving in and living in my property. Can't do that, okay? You got to make certain that everybody's on the same page, all right? Does that make sense? Thank you, ma'am.
You're welcome.
Tonight's a busy night, everybody. So in these particular situations, we have to make certain that everybody is on the same page, that everybody is working in the same order, and that we're moving along, okay? So everything needs to be agreed upon, okay? Now, the maintenance of the premises. The tenant must return the property in the same condition that's received, and reasonable wear and tear is going to be exempt. So if I go and I rent property from Miss Leland, and I live in that property for 2 years, while I'm living there in Miss Leland's property, of course, I'm probably going to have scuff marks, and I'm going to have little things on the wall and stuff like that, just wear and tear. Carpet's going to wear and all that. But if I go and I punch a hole in the wall, what ends up happening? I got to fix it because that's not wear and tear. And if I don't fix it, she can take it out of what? Out of the security deposit. Okay. So again, the landlords, they're going to have unit and common elements must be in a habitable condition. So Miss Leela cannot, in this situation, Miss Leela cannot turn around and make it where I have no AC or no heat, or I have rain coming in. I have to make it habitable. Okay, it has to be able to be lived in. In regards to smoke alarms, they must be installed in all residential rental property. All residential rental property must have smoke alarms, unless it's rented under 90 days through a sale. Okay. It must be in each bedroom and a corridor that serves those multiple bedrooms, and must be installed for the hearing impaired if asked. It must be in good working order when the tenant moves in. That's the key. And it's presumed to be working until the tenant requests it be repaired. Okay, so if I move into your property, Miss Linda, all right, and it was working at the time I moved in, I'm covered, or you're covered. But it is now my responsibility to do what? I must replace the batteries, but if the batteries doesn't fix the problem, then what do I have to do?
We have to replace
I have to, well, I have to contact you as my landlord to come fix it.
Right.
Okay, but my only duty is what? Just replace it.
I have a question.
Yes, ma'am.
What if you have some of those smoke alarms, people take those smoke alarms down?
Yeah, I've had that happen before. They take it down, they take it down.
Right. So how do you work that?
So if they end up, if they take it down, then it's on them individually. So say Stephen and I are moved into your property, Miss Linda, and Stephen, he hates dealing with the smoke alarms because it's making noise. Okay. Well, Stephen takes him down. Well, if Stephen takes his down, what ends up happening? Well, in that particular situation, if he takes it down, what's going to happen in that particular area? That's his problem. Okay. Security devices. This is very key too. They're specified by law. There has to be window latches as well as doorknob locks. Okay. Sliding door handles must have latches and pin locks, and keyless deadbolts must also be there. Door viewers on each exterior door must also be available. And there is a 7-day to rekey locks after the new tenant has occupied. Meaning that as a tenant moves out and a new one moves in, you got to do what, Mr. Eugene?
Change the
You
lock.
got to change the locks. Okay? Now, let me come back to this. Mr. Eugene, can you go out there yourself and change it, try to change the lock yourself? And I've had people do this before, can you do this? So Stephen lived in the property for 12 months. You had the handles on it. You took the handles off, okay, and you go put those into a box and you put new ones on. And then I live there for 12 months and then I move out, Linda moves in, and you take the one from when Stephen was there, put that handle back on there, took mine off. Can you do that? No, because what's the problem? He has what?
Yes.
He has still the keys. Now you could re-put that lock on there, but you have to re-key the mechanism so that Stephen cannot get into that property. I used to work for a guy that did that kind of crap, and I was like, that just, no, too much of a liability. Now, termination of lease, okay? They may be terminated by the expiration of the lease term, which is the estate for years. They may have a notice from either party, which is usually going to be in writing. The periodic estate and tenancy is at will, and it's generally a 30-day notice. Again, active military duty is another reason that you can be terminated, or a victim of family violence or sexual assault under certain circumstances. Okay. The landlord termination of lease and eviction, if the tenant breaks the lease, could be a discharge from the lease. So there could be a situation where if the tenant doesn't follow up or do their part, they get evicted. That would discharge that lease. If there is a mutual agreement, both landlord and tenant say, yeah, I want to break this lease. Okay, we're in agreement. That's fine. If there's a tenant abandonment, the tenant just up and leaves, the tenant's liable for the terms of the lease, okay, including their rent, but the landlord then has the duty, though, to try to mitigate their damages. The termination does not occur in some situations. When the owner or the tenant dies, that also can discharge the lease, but the heirs are, of course, still going to be bound to that lease. Just because the party dies, the lease still stays in effect on that estate. The landlord of deceased tenants has duty to, of course, mitigate those damages, and when the landlord sells the property, again, the purchaser, like we said earlier, is bound to the lease. Again, a breach of contract can also be a way for discharge. The landlord, of course, number one, could do what's called a lockout remedy. Sometimes if Stephen doesn't pay his rent, I can put a notice on the board that if I don't get my rent paid within, 2-3 days, I'm going to lock you out. Now I have to give Stephen notice of this, but here's the thing. If I change the locks on Stephen, so say that I give him 3 days, he's not paid. I call you, Mr. Eugene, I say, you're my maintenance guy, go out there and change the locks on that property. So you go change all the locks. Well, guess what? Mr. Eugene, you get to stay up for 24 hours because you have to let Stephen in to the property if he gives you rent, even if it is 3 in the morning. Okay? So you cannot, in that situation, lock him out of the property. You have to have a 24-hour phone number so that they can be let back in if they pay. Again, there is a suit for possession, and which is the actual eviction, and the tenant's remedy is, of course, a constructive eviction. A breach of contract, of course, like we said, a landlord's lockout remedy for non-payment of the rent. They must give the tenant 3 to 5 days notice that locks are going to be changed. They have to also state the amount that's due and designate where the rent can be paid to avoid that lockout. You can use the lockout remedy only once per payment period. So you can't keep changing it, if that makes sense, okay? And if the locks are changed, there is no legal resident can be inside, okay? And the landlord must leave written notice on the door of the amount and other charges due, and a 24-hour address or phone number for the tenant to get a key. If no on-site location for key pickup, then the owner must deliver a key within 2 hours after the tenant calls. So that means that Mr. Grossman calls you at 2 in the morning, Mr. Eugene, you have to give him a key by when? By 4 in the morning. But Mr. Grossman, where are you going to go for 2 hours?
I don't know, I'll sit on the roof or something.
Sit on the roof or sleep in your car, right?
Something like that.
A suit for possession, which is the actual eviction. It's where for the breach of any terms of the lease, the owner must give a 3-day notice of suit, and the suit for possession or forcible detainer suit must be filed, and it has to be heard in court within 10 days. If the court does issue a judgment for possession to the owner, then the tenant has 5 days that they have to appeal. Again, after those 5 days of the appeal, the court may issue what's called a writ of possession to the owner. And within 48 hours after receiving the writ, the owner must deliver the written notice to the tenant that the writ will be enforced. The tenant must remove himself or herself and their possessions. Now, let me tell you, they don't play with this. They will literally send a sheriff to your house, and guess what they will do? They will forcibly kick you out of your house if they have a writ. They will literally grab you and throw you out. Okay? Now, again, like it says, if the tenant does not vacate, the deputy, sheriff, or constable who will oversee the forcible remover of the tenant in possessions, and during or after the eviction suit, the owner can file suit for damages, lost rent, and attorney's fees. Okay? So, of course, you don't want to be dealing with this type of lawsuit. A tenant's remedy is a constructive eviction. If the certificate of occupancy is revoked, meaning that the city comes in and says, yeah, this occupancy, this place is not a stable place to stay, the landlord must return the security deposit and the prorated rent, as well as reimburse the tenant for expenses. If the landlord breaches the lease, the tenant can sue for those damages. If the premises becomes uninhabitable, okay, the tenant may abandon them in regards to what's called a constructive eviction. Okay. Now, to claim constructive eviction, the tenant must give written notice to the landlord, and it must abandon the premises while uninhabitable. The tenant is entitled to what's called a pro rata refund of the rent paid, or seek court order requiring repairs up to $10,000 and awarding damages to that tenant. The other types of leases that are out there, of course, are your gross lease, your net lease, your percentage lease, your variable lease, gross lease, and oil and gas lease. We have already talked about each and every one of these already, but the key thing that you need to be aware of is each of these are different in regards to how they're going into them. So, for example, Miss Linda, say that you're wanting to rent a property. You need to be aware of how these can be broken down, because in some situations, a normal residential lease is going to be what? Well, a normal residential lease is you pay $2,000 a month, that's what you're going to pay, nothing else. But in some of these leases, they can include where they can say, Stephen, you're going to lease this office building, so you're going to pay $1,500, but you're also going to pay taxes, the utilities, building repair, commons repair, all these different things. So you pay $1,500, but you also have to pay for all these other expenses. So you have to be aware of each of these different types, and we'll go through those in more detail when we get into our prep course. But you just need to know that there are these different ones that are shown up here. Okay? All right. So with that being said, that covers everything in regards to our leases that we want to talk about this evening. So Mr. Grossman, if you would not mind, could you go ahead and stop our recording for this night or tonight?